Hi, everybody. This is Advocate Lucinda, your empowerment lawyer. I have had a number of people to ask me questions about the motion to compel, specifically the motion to compel discovery. The question is, what can I do when the judge denies my motion to compel? Well, the plaintiff has two options: the interlocutory appeal or appeal as of right. And we're going to talk about that right now. So let's get started. I always like to go back and do a recap. So we know that the ideal situation is for the plaintiff and the defendant to agree to exchange documents without objections, right? The truth is, plaintiffs and defendants don't always agree with exchanging documents. And that's okay, as long as the parties' disagreement is in good faith. Remember, prior to filing the motion to compel, the plaintiff must confer with the defendant. They must try to work out their disagreement. After the parties have conferred, the plaintiff must prepare a good faith certificate, and the certificate must accompany the plaintiff's motion to compel. This slide and the next 5 slides will show a side-by-side comparison of the interlocutory appeal and the appeal as of right. The code sections that cover each is 28 U.S.C. Code Section 1292 and Federal Rules of Appellate Procedure 3 and 4. So let's talk about the status of the lawsuit under both theories. When a judge denies the plaintiff's motion to compel, it is an interlocutory order. It is the non-final trial court order. It is not the court's final order. The lawsuit continues. Whereas in appeal as of right, the court has entered final judgment of the lawsuit. The lawsuit has ended in trial court, and there is nowhere else to go but to the appellate court. So let's look at the issue or issues. So it's an interlocutory order because the court adjudicated a discovery issue, right, that the plaintiff disputed. Appeal as of right. The court has issued a final order, not just on the discovery, but on all the plaintiff's issues. You got it? So again, the plaintiff is appealing the discovery issue that is the subject of his or her motion to compel. On the other side, the plaintiff is appealing one or all claims in the lawsuit. So let's look at the right to appeal. Under interlocutory appeal, the right to appeal is not automatic. The plaintiff is required to get permission from the appellate court to appeal the district court's non-final trial court order. Whereas as appeal as of right, the right to appeal is automatic. That's why it's called an appeal as a matter of right. The time to appeal. In an interlocutory appeal, it is in the discretion of the court to permit the plaintiff to appeal the trial court's order. The application must be made within 10 days after entry of the trial court's order. Remember, the trial court is the district court, and that could be found at 28 U.S. Code Section 1292B. Whereas appeal as of right, the notice of appeal must be filed with the district court clerk within 30 days after entry of the judgment or order appealed from. You will find this at Federal Rules of Appellate Procedure 4A1 capital letter A. Be sure to read those code sections. Another thing I want to say about interlocutory appeal is that even though the plaintiff has applied to appeal the judge's denial of his or her motion to compel, that does not necessarily stay the proceedings. In other words, the other issues continue in litigation. So an application for an appeal hereunder shall not stay proceedings in the district court unless the district judge or the court of appeals or a judge thereof so shall order. Well, what if they don't order it and nothing is said? Absent a court order staying the proceedings, consider filing a motion to stay. Now, ask the opposing counsel defendant if they would object to you filing a motion to the court to stay the proceedings until the court has decided whether it's going to accept the application for appeal, and if so, will the court allow the proceedings to stay until the appellate court decides on the plaintiff's interlocutory appeal. Okay? I hope this has been helpful to you. And thank you for your questions and your comments, because we want to empower you. Until next time, I am Advocate Lucinda. Be empowered.